Excuse me. Listen. Let me tell you something. If you don't stop when I tell you to stop, I'm gonna take you out of here. We're not getting into whether somebody has a license to practice law. Okay, let's release the. Now, you're not getting another one. I'm just telling you.
I reserve the right for judiciary finding on the legitimacy of the court.
You're not getting another one.
I did an extra 30 days.
Well, if you keep this up,
That's my attorney.
you're gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to. I'm really actually having to dismiss.
No.
The simple fact that
We're not doing that. 5-00791 FY State of Michigan versus Timothy Dansby.
Yeah, people.
7446, standing in for the attorney of record, Gonick, and appearing on behalf of Mr. Timothy Dansby, who stands to my right. Mr. Dansby, can you please state your full name for the record?
Timothy Dansby.
All right, Mr. Dansby, we're back. Do you mind having Ms. Miller stand in for Mr. Gonick for today's hearing?
That's up to the court. I still reserve my right. I mentioned all of the previous hearings, but part of today's process has been going what it's going to continue doing what it's doing. But I still.
Does that mean you don't mind her standing in?
Want to interpret?
Okay, you know what? I'm not gonna play that game. That's a yes or no question. Okay, do you want to adjourn it and see who it is? You have a right to have the counsel of record present if you want to be here instead of Ms. Miller. And this is basically for a probable cause conference and adjourn date on a retail fraud first degree. When we had adjourned it before for your lawyers to get video discovery. So do you mind her standing in or no? Okay, so you don't want a lawyer, sir? I'll release him if you don't want one. Nobody's gonna force you to have a lawyer to help you. If you want to do it all yourself, do it. Do you want me to release the lawyers?
Same firm soon right now.
Do you want a lawyer? Yes or no? It's a real easy question, sir. It don't take all day. Listen here. Okay, if you don't answer the question, I'm going to release the lawyers. If that's what, because you've been complaining the whole time about, I didn't ask for no state attorney. I don't want to, I don't know what it, whatever you going to do. No, I'm not doing anything. I didn't appoint the person in the first place. I didn't do it. Okay, so you don't want them? Is that what you're telling me? Do you want them? Yes or no?
On the same.
Sir, listen, this is not going to be a matter of semantics. Do you want one or not? Because nobody's going to force a lawyer on you. I'll be happy to handle this case with you by yourself, doing whatever you can do to help yourself. If that's what you want.
I still ain't got my discovery,
So, do you want a lawyer?
I'm sorry, I'm still on the same thing.
I don't even know what that is. Whatever your claim is, I don't know. Okay, let's release the lawyers. All right. Now, you're not getting another one. I'm just telling you.
I reserve the right for judiciary finding on the legitimacy of the court.
You're not getting another lawyer, okay?
I said
I don't know what you can reserve what you want. I don't mind.
finding of the court in the legitimacy of the court as far as the defense argument practice.
Sir, whatever you want to do, you can do. But since you don't want a lawyer, I can't by law give you one. So,
That was three adjournments ago.
guess what? So,
Lord, have you given me the things that I need?
okay, sir, nobody can give you anything but a piece of paper. They can give you that. They could give you the police report. They cannot give you the videos because there's no way for you to watch them.
Make sure that the law library at the court, it will order that the law library at the court either have a clerk or somebody to present the information for me to see the video. I don't know, maybe you just don't want to get done.
Sir, I don't even know. I don't know anything about your law library wherever. All I know is these video files, they're files. They come on a computer.
So, the law library should somebody should be giving people at the law library a heads up to make it.
Well, you know what? That's up to you to figure out how you gonna get them.
I'll let the second sort figure it out. Let the second circuit figure it. Probably just second court, Supreme Court, we let them figure it out. I'm straight. Well, I ain't doing nothing.
Ready for me to take them?
Your Honor, would you like, Mr. Donovan to file any sort of motion or
No,
hold order to have him withdraw?
no, I'm gonna write an order out right now, releasing him.
Your Honor.
And so we will reset this, I guess. I don't know why we got him. We could actually bring him back out and he could decide what he wants to do today.
I do know that, he is wanting to have his preliminary examination, that is.
Okay, well, let's set it for an exam then. How many witnesses, Mrs. Shockley?
Probably just gonna be one.
All right. You want to wait for your order, you can.
Okay, thank you. One witness.
Right.
Yeah, one witness and one defendant that's gonna make it way longer than it's supposed to be. So factor that in.
Court's available October 3rd at 10:30.
All right. So October 3rd at 10:30. Is the exam date. And could you ask Mr. Gonick to make sure he gets a discovery, what he has, over to this person?
I believe that paper discovery has already been given to him. I'll see if the court or if the jail will allow us to give any sort of thumb drive or anything like that that encloses the videos.
This record, I would advise the court, the discovery, the AV discovery in this matter is 99% police body worn camera, which has the defendant in it, and there's only one in-store video of the defendant walking past that. So. You
Okay.
didn't know it.
Okay. Well, good. Just make sure he sees it.
That's
Just
what I'm
some of your best efforts on that. And people of the state of Michigan versus Timothy Dansby. Sir, what's your name? All right, Mr. Dansby, good afternoon. Mr. Shockley, place your appearance on.
Track on behalf of the people.
All right, today is the date scheduled for a preliminary examination. This is on one count of retail fraud, first degree. People prepared to proceed.
Yes, Alex.
All right, any preliminary matters?
Did you, pursuant to the court rule, confirm that the defendant still wishes to represent himself as this is a critical proceeding?
No, but do you still wish to assume he did?
Yeah, they just have.
He's been-
Voluntary.
He's just been asking all this time, would you still want to represent yourself? You've been telling us all this time, do you want to represent yourself?
I've been wanting to represent myself.
Okay, so you want to proceed today by yourself without a lawyer, right?
Not before I let it be known that I still never received my full discovery.
Well, what haven't you received, sir?
I haven't had a chance to go over the videotape because one of the witnesses in the videotape that I know that when I was speaking to him and was saying, letting him know that, look, man, put this stuff back on here because I'm choosing not to buy it here and I'm going someplace else. So it wasn't like I was trying to steal nothing when I told the guy this particular, I wanted to make sure that he's be available to be questioned.
I don't know who he's gonna call. See, this isn't a trial. So this is just your probable cause hearing. So the prosecutor has a very low threshold burden of proof. He doesn't have to put on every witness, he said. He doesn't necessarily have to use the video. He might. And if you say the video means something else, that creates a question of fact that would go to trial for the trier fact to resolve. And of course, you get an opportunity to question about the video in depth at trial.
Also, I'd like to mention the fact that, you know what I'm saying, that it's been a delay because I don't know who these people have been coming up here. I've been telling the court that I've been wanting to represent myself.
Well, you've been representing yourself since the last time.
Well, I've done with them saying at the county jail, they said without the court allowing them to know that I was representing myself, there was certain information I couldn't get. They would not give me. Like the Michigan court rules of evidence. You know what I'm saying? For part.
I've never heard of the court having to tell the jail you're representing yourself.
No,
I've never heard of that.
the new technology, they used to have a law library you could go. But now you do everything over the computer.
Okay.
You got to leave a request. In order for them to fulfill your request, they have certain criteria that you got to show ahead of time.
Well, sir, I don't know anything about what the jail's criteria is.
And also, you know, I'd ask, you know, for a standby lawyer.
But they don't do that.
But from my understanding from previous experience, you know.
What
From
what year was that?
Federal circuit court and from other court.
Federal Circuit Court.
No, I know, yeah, circuit court, they have done.
This is the state system.
There has been opportunity to have standby lawyer for instances where they could confer certain information that the prosecutor might not want to give to me because he might feel he's better than me or something. Because he feels that my constitution right.
Listen, Mr. Dansby, we can't
He
keep,
might allow me to receive.
no, of course you got, that's not true. You have a right to represent yourself and you do have a right to get discovery. But what you can't do is come in here on the day of the hearing claiming that, oh, now you want to stand by counsel.
I said,
Okay, but I'm telling you,
I'm just saying, well, from my
Well.
experience, it's always been, standby counsel been set.
I don't know what your experience is. I just know what Michigan and
I
I don't know when you got,
Well, of information.
okay, sir.
And
The Michigan Indigent Defense Rules, they have a whole new program that's been started a few years ago. So we used to do standby counsel and anything like that. We used to do that all the time when the court was appointing. Now they have a whole system. They don't pay for that. They say if the defendant wants a lawyer, fine, but there's no quote standby lawyer in their view, so they don't pay for that. I didn't make that rule. The person,
I couldn't verify it if I wanted to without.
well, the person that,
Without the people in the jail who's running the law library information, able to send me the information that I need, because without them having, and for their quote.
okay, what information
Their
do,
quote unquote.
sir, what information do you think you need just for a preliminary exam?
Your Honor, just-
No, I said for Michigan Indigent Defense appointment.
So then, you said it used to give standby counsel.
I said we did before that system was created.
I'll be chance to update on the system, yeah.
Okay, but that has nothing to do with this.
Court rules of evidence.
Your Honor, I'm gonna, just so I can expedite this, and to satisfy the defendant, at the circuit court level, the circuit court has the budget and the ability and the staff to appoint a standby counsel once he gets up there. And once we finish this hearing, he may be up there and he can make that request then, and I'm sure the circuit court will have no problem immediately assigning him an attorney to advise him as he represents himself. As far as the people are concerned, the court has been complied with. He's freely and voluntarily relinquished his right to an attorney. May I call my first
So the
witness?
court, yeah, I like to also state that I still haven't received my discovery, and my date was proposed because of some guy who said he was my attorney, I did an extra 30 days, the extra 30 days.
Well, if you keep this up,
That's my attorney.
you
Why
gonna,
wasn't my,
you gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to talk. I'm really asking to have it dismissed.
No,
For the simple fact that.
we're not doing that.
Okay, or ask for a personal bond because I didn't have my case adjourned on other people's. It had nothing.
Sir, you the one that asked for new lawyers or
I
no,
didn't ask for
or no lawyer.
I asked for any new lawyer because I never accepted the first. I have never signed for an appointment of an attorney from the very beginning, even at.
Okay, sir. Well, we're gonna proceed with your preliminary examination without a lawyer. So you should be happy today that you don't have one. And then when you get to the circuit court, ask them to give you a lawyer. He just said they have a budget for that.
Ask them to give me my discovery.
What discovery don't you have? What tape?
Yeah, all right, I'm gonna play the tape for him, today anyways. There's no right to it. There's not even a right to discovery before a preliminary exam, technically underneath the court rule. I mean, we deal with this all the time. So this is just an intermediate proceeding. It's not gonna affect anything. As you know, attorneys don't even ask questions a lot of times during preliminary exams because it creates a question effect.
But they certainly don't call, they might ask questions, but they don't call witnesses.
Not in all situations. With all the preliminary exams, but there's.
Okay, have a seat, sir, unless you want to stand up for the whole hearing. Call your first witness.
People go to the same Robert Stanley.
Okay, Mr. Shockley, are you ready?
I am ready.
Okay. Raise your right hand. Do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, thank you. Have a seat. And Mr. Shockley, whenever you're ready.
Yeah, sir, when you are ready, will you please state and spell your name for the record? Who is your employer?
Meijer,
What is your job title with Meijer?
Asset Protection Team Lead.
Asset Protection Team Lead?
Yes, sir.
And how long have you been employed in that capacity by Meijer?
Since January of 2025.
Did you receive any specialized training to have that title or that role?
Yes.
And what do you do? What kind of training?
So it's a multitude. So over years, Wicklander certified, and then different courses in asset protection and policy related.
Were you employed in that capacity on July 26, 2025, around 5:30 p.m.?
Yes, sir.
And so do you work at a specific Meijer store or multiple stores?
I'm assigned to the one in Southfield.
Is that located at 28800 Telegraph Road,
Yes.
City of Southfield,
Yes.
County of Oakland?
Yes.
On that date, around that time, did you identify a retail theft in progress?
Yes.
And how did you identify that?
In this particular case, it was just rapid selections of similar merchandise.
What do you mean rapid selections?
So one of the indicators of theft is grabbing merchandise without looking at price or without appearing to look at price, size, that kind of thing.
And how did you see this occurring?
On the floor.
Were you physically on the floor or were you watching cameras?
Sorry, I was physically on the floor.
Did you follow this individual
I did.
as he was selecting items?
Correct.
Do you see that individual you were following presently in the courtroom?
I do.
Will you please point and identify an article of clothing he is wearing?
It's the over to my left, and he's wearing like a blue shirt with a white t-shirt.
Your Honor, may the record reflect the proper identification of the defendant.
Yes, so ordered.
Upon following this individual, did at one point he come to the point of sale?
He did.
Was that before, at any point did he try to walk out before coming to this point of sale?
No,
Did he have a cart or was he concealing these items on his person?
it was a carton.
Was that cart full?
Yes.
Upon him going to the point of sale, what did you, just so we put, you were at the point of sale when he got there.
I was, yes.
And what did you see him do at that point?
He went up to a cashier and myself and asked where the bathroom was.
Was that before or after the cash register?
That was, it's kind of at the same time. It's like at a, it's like a giant area where there's like self-checkouts.
Are these self-checkouts?
Yes.
Is there a long looping line to the self-checkout?
Correct.
Did he still have the cart with him?
He did. So he left the cart, actually by me, and then he went to the restroom.
What did he do? Did he come out of the restroom?
He did.
What did he do upon coming out of the restroom?
He grabbed a cart and proceeded towards the opposite side of the store, which would be the grocery side.
And what did he do upon getting to the grocery side?
He pushed the cart out, exiting the store without offering payment.
Did you, stop him at that point?
Yeah.
Did he say anything to you upon stopping him?
He said, I can't recall exactly what he said.
But he did say something?
He did.
Okay, and what did he do upon you confronting him?
He walked past me and then went out the doors going to on the grocery side into the parking lot.
Did he abandon his car or did he try to take his car with him?
He abandoned it.
Upon scanning these items, was a receipt produced?
It was.
Yeah, then may I approach the witness?
Yes.
People propose exhibit one. What is that?
It's a receipt from Meijer.
And does it fairly accurately depict the items you scanned from the cart?
Yes.
Has that receipt been edited in any way to your knowledge?
No.
People will go to that people's exhibit one.
Show it to the, okay, sir, that is People's Proposed Exhibit 1. Hello? Well, he's offering it. Is there an objection? Okay, no objection heard, admitted.
Sir, does, Meijer take cameras?
We do.
And were those cameras working operational on that day?
They were.
And did, upon him leaving the store, did you contact law enforcement? Did law enforcement come to your location?
They called him, like in the, they went towards 12 Mile, made a right. I'm sorry, I don't know if it's east or west, but made a right. And then they caught it right there. And then they came.
So, okay, so to answer my question, law enforcement did come to your location?
Yes.
Upon them coming to your location, did you show them video for this then?
Yes.
Previously to you taking the stand, did I show you what's on the splash drive?
Yes.
Is what's on the splash drive, the videos from Meijer that day?
Yes.
People will move to next people's proposed exhibit two.
Any objection?
People's proposed exhibit two is the camera footage from Meijer, correct?
Yes.
And that's the same footage we turned over to the police?
Yes.
People will move to next people.
I object to the fact, John, I haven't had a chance to go over, take previous to the examination. You know what I'm saying? I like to state for the record that being able to go over there would be part of my discovery. And since the prosecutor said, I guess upon his word, I guess he's making precedents that you don't have to give.
But why don't we do this, sir? Let's play the video without admitting it so you can watch it. Then if you have an objection, you can lodge your objection at that time.
Step out.
Yes.
All right, sir. Head back to your seat. So that's the video that he seeks to admit. Do you have an objection?
Yeah.
What is that?
Complete video of the incident that happened. Because at this junction right there, I was going to the bathroom and I did not go past.
Okay, but sir, that's an argument. You can make an argument later. The question is this the video that purportedly was taken by Meijer cameras and turned in by this witness to the prosecutor's office? He said that's what it is. Now, you can question the validity of it, the length of it, how long it was, but doesn't affect the admissibility of it. So, okay.
I don't have access to go over the reground and take myself, yeah, because I haven't been allowed my copy of the tape or the
Well, it's
electronic.
not your time to ask the questions yet. You get a chance to.
I don't have a copy of the tape to go over.
Sir, you don't need it. You watched it.
Well, I'm watching it, I'm trying to verify what's going on.
Okay, but you're not doing it right. You have to wait till he asks the witness questions,
Okay.
and then you'll get a chance to ask the witness questions too.
Sir,
I'm on it.
you see the person in the middle of that video that looks like he's got a white stripe at the bottom of his leg?
Yes, sir.
Okay, is that the person you identified as the defendant?
Yes, sir.
Okay, that card he appears to be holding it in his hand. Is that the card you took the items out and then scanned to create that receipt, which was People's Exhibit 1?
Yes, sir.
Okay, people are good.
Where's the copy?
It's right there at the entrance by that lady in the blue shirt and pants. She's holding it.
How did you get there?
You were,
I think that,
sir, if you watch the video, it shows you, he identified you pushing the cart. And when he got to that part, they stopped you
okay.
and took the cart.
Now they took the car, but there was an individual, it was a young black male.
Okay, sir.
It was, hold on, y'all.
But just, you're not testifying.
It was a young, I'm not testifying.
Yes, you are. You're trying to tell us your story and this
I'm
is
trying to
not.
tell you that the tape, this is not the full tape.
Okay, this is not the time.
This is not the full tape.
Okay, sir.
This is not the full tape. How can you show half of the tape and then the signal instead of showing the whole tape? From the times that I left from the times that I left, the black parts with the where I was paying for the tape and walked in there, it's the whole step was missed. So where is the technique?
The sovereign citizen pattern is showing up now. Instead of using cross-examination to attack facts, he keeps chasing the video itself. That can feel smart in the moment, but it burns the few chances he has to challenge probable cause where it actually matters.
That was one item I was looking at, 20712. Okay, are you finished?
I'm done.
Okay, sir, cross-examination now.
Okay, I'm gonna need to know.
He can play it.
Okay, now,
What do you want him to play?
if this document right here, this is Shockley,
Sammons.
Sammons,
Yes.
this is Sammons. If this point right here, when the defendant left him, the self-pay machine was walking towards the cash register where it would be taken in, and you went that way, at which point did you start walking behind? Can you run the tape? At which point was you walking behind the defendant, letting him know that you'd already called the police?
I don't understand. I'm sorry, sir. I really don't understand your question.
Okay, at one point when you put that out there, put him. Yeah, and you came behind and said, "I'm gonna come to my office, I already called the police."
Yes.
Stop.
This take,
Mr. Shockley is gonna make his motion. Go ahead, Ms. Shockley.
Moved by the defendant over as charged. As you know, this is retail fraud in the third degree. It's enhanced from a second to a first. Dollar amounts over $200. The video shows in the testimony, Mr. Sammons shows that he attempted to leave the store without making any ability or offer to pay for those items. Accordingly, we custody is bound over as charged. Thank you.
Yeah, what do you want to say by way of argument now, sir?
I'd like to say, Your Honor, that it's been such a long time, I never had a chance to get the tape. You know what I'm saying? And I also like to state,
You went over that tape ad nauseum today, sir.
like, you know, that tape, the prosecutor, didn't have to take so long, but that's not exact, that tape doesn't exactly show what happened. But that individual was walking behind him. I don't know how you did that, you take, that's why I was looking for the time. And also, I like, again, just for the matter of convincing that impropriety on the way the examination was ran for the simple fact that the days and the time that it took, even though the prosecutors did show his willingness to show the tape, did not give me a chance to go over the tape. Since we've been postponing this, I haven't had a chance to even call, and I still, to this joint, don't know the witness name of the individual that.
Sir, you got plenty of time to find the witness and call them for trial. This is not a trial.
I'm gonna do it, Your Honor, if I can't get the paperwork.
What paperwork?
I can't get the discovery, mostly for discovery.
You got a folder full of paperwork. A police report, right?
I'm talking about, Your Honor, the paperwork in order to get the discovery, to get.
And I don't know what paperwork you're talking about.
Rest of the discovery, the motion, to be able to write the motion for the discovery.
No.
The
You-
Michigan court rules to determine that, the Michigan, or you don't know the Michigan court rules to determine that the prosecutor must.
No, you know what? I have no idea even what you're talking about at this point. You got the police
Also, I like-
report, which gives you all the information.
And for the last.
Mike, I'm not quit talking.
I like to put on record.
I'm just gonna stop talking. You can take over this whole courtroom. Go ahead. And you got about 3 minutes to do it.
All right, for the last statement, I like what state for the courtroom, still that the court never actually showed its authority to trial the individual, because I don't know if this prosecutor, the court, even have license to practice law.
Okay, no, we're not going down that road. Excuse me. Listen.
I don't have, hold on, I got a right, I got a constitutional right.
Let me tell you something. If
Stop talking to me.
you don't stop when I tell you to stop, I'm gonna take you out of here. We're not getting into whether somebody has a license to practice law. You are to contain,
It's a legitimate argument.
you are, listen, you're to contain your argument to the facts
And it says the fact.
on this case,
From
this on the record.
the Bar Association, it said that it is not a licensed agency. So if you got a bar practice without a license, which the Constitution of the United States and the state.
Sir, I'm not gonna listen to that.
No state,
Nope.
no city, no township, municipality can make a law contrary to the.
Nope.
The highest law of the land. And I would like for that to be placed on the record.
It's placed on it. Now, you're done. The defendant is charged with a retail fraud. All the elements were met in this matter for retail fraud first degree. The testimony clearly established that the defendant took property of the store that was offered for sale. It showed by way of testimony that he took property off the shelf in a random manner. All the testimony was all the same things without looking really at the prices or the tags, it seemed like. That he moved the property, well, he put it in a basket and walked all around the store from one side to the other. Third, he intended to steal. That's a question of fact as to whether or not he intended to permanently deprive the store without the store's consent. However, it was clear from the video shown that he walked from one entrance to the other entrance without paying for anything and was attempting to push his cart through the entrance when he was stopped by loss prevention from doing so. That's the question of fact as to why he was doing it with the intent to permanently deprive or not. And this really happened inside the store while it was open to the public and without the consent of Meijer. The items were tallied up by loss prevention and came to $207.12. So clearly, that's enough to satisfy the court that the retail fraud did occur. And of course, there was an allegation that he apparently had a prior conviction, April 17, 1989. For retail fraud first degree in the Sixth Circuit Court. So that's the sentencing issue, and that's enough to bind it over on the first degree and continue to bond. Mr. Shockley, here is your exhibit back. His bond is continued. Make sure you get a license to practice law, please.
And don't present doctored video. Video's been doctored and altered. Oh my God.
This hearing shows how small courtroom choices create large legal consequences. The judge was not deciding guilt beyond a reasonable doubt today. She was deciding whether enough evidence existed to move the case forward. That is a much lower barrier, and missing that distinction can cost a defendant badly. Throughout the hearing, the defendant focused on discovery complaints, side arguments, and legitimacy claims about licenses and authority. Those arguments are common in sovereign citizen circles because they promise a shortcut, defeat procedure instead of confronting evidence. But courtrooms usually run the opposite way. Judges focus on elements, admissibility, timing, and whether minimum proof has been met. That matters here. The witness gave identification, described movement of merchandise, described the exit path, and tied the receipt to value. Once those facts entered the record, the real danger was no longer rhetoric. It was momentum. Cases often advance not because every question is answered, but because enough boxes are checked. Self-representation can work only when a defendant uses discipline, narrow questions, relevant objections, and clear factual challenges. Without that structure, frustration starts replacing strategy. When that happens, the court keeps moving while the defense stands still. The final lesson is simple. In hearings like this, people rarely lose in one dramatic moment. They lose through dozens of smaller choices that seem harmless at the time. And once a case moves uphill, every next decision becomes more expensive than the last. Stay with this one.